Where are we on now, Sean?
Sean Domingo, there is a request for a protection order. Is Perez Gabriel in the courtroom? Perez Gabriel.
Elizabeth
Good
Sanders.
morning.
Elizabeth Sanders from Mr. Domingo.
Your Honor, Rosemary Leite, certified court interpreter, Spanish English.
As to bond.
Asked on Your Honor, Mr. Domingo has 0 failures to appear on his ORS score of 1. We did go over the deferred protection order and he's okay to execute that. He is in the process of doing that right now. I would note, Your Honor, that he does work at Smithfield Packing. He's lived there for 1 year and 6 months. His whole family is here in Ohio. I would also, he does also have another place he can stay in the meantime with his sister, Teresa. I would ask Your Honor to consider an ORSOR with the execution of the TPO.
From the state.
Judge, the victim in this case is a person that he has a child in common with. There was visible injury when the officers were on scene, and he has a recent domestic violence dismissal.
The Spanish copy of the TPO is provided.
$2,500 anyway, plus juris if requested. Estrada. Good morning, Councilman.
This is just an alias, that's why the names are.
Thank you.
Your Honor, interpreter present.
Waive probable cause
So,
as to bond.
I don't think I have this here.
just wait, probably cause as to, bond, it is the second time OBI does have a felony that's associated. Strong family support, I believe there is a order on now, but as for a bond to be set, be reasonable bond. This family was supposed to work with them on that as well.
From the state.
Your Honor, this is an OBI attached to a failure to comply. It is a second in time, second overall with a prior in 2018. No accident, insurance was marked no. It looks like there is a urine test pending. Because of that, there is no ALS in place, so I would ask for a public safety suspension.
I'm okay with Bob.
Public safety suspension impose $2,000 anyway, plus TAD. No alcohol is a condition of bond on, that's on the OBI. On the failure to comply, $2,500 anyway.
Thank you, Your Honor.
Morales,
Grand jury report on that will be 8/25.
8:25.
Thank you. Is that everything?
Yes, everything's working.
Morales? Ms. Morales?
Good morning, Your Honor. Please not guilty.
All right. As to bond.
Your Honor, I don't believe she has any prior criminal history that I'm aware of. She didn't provide me a valid address. She does reside there with a family member. She also is employed. She works at a factory job, making frozen food. Based on her lack of any record, we would ask the court for an OR bond. She understands that she cannot drive right now, and I have explained that.
From the state.
Your Honor, it looks like police were called because defendant had hit multiple mailboxes. She was passed out behind the wheel with the keys in the ignition. Looking at the ALS, there was a breath test. It was 0.130. However, the box that needed to be checked for placing her under an ALS was not checked. So based on the test above 0.8, I would ask for a public safety suspension.
Public safety suspension is imposed. This is a first ever, what was FRA mark?
It's not marked on the ticket.
OR.
Thank you, Judge.
Sales or sales?
Judge Lopez not guilty on behalf of Mr. Salas.
All right, as to bond.
As to bond, Judge, he's 26 years old. He does live here in Cincinnati with his wife and their 3 children, age 6, 9, and 5 months old. Judge, he works in construction. He's been doing that for about 3 months. Judge, I show no record. He has 0 failures to work here. He has family support. Judge, I will be filing a notice of self-defense. And Judge, he does have somewhere to stay. He can and will stay away from the prosecuting witness.
Did you say no record?
Correct.
There's
No
a
record.
domestic violence out of Westchester
I see. Judge would ask for an OR.
from the state.
Judge, it looks like they're charged in the alternative. They're charged for the same conduct. The defendant in this case chased the prosecuting witness around with a knife, attempting to cause him physical harm. I would ask for a stay away from the prosecuting witness in this case, as well as a monetary bond for the seriousness of the charges.
$1,500 anyway on each count plus juris if requested.
Judge, would you consider an alternate OR EMD?
Not with a lead weapon involved. Vasquez.
Judge, so please not guilty on behalf of Mr. Vasquez.
All right. What number is this?
Judge, based on the local records, like a first time.
accident,
There was an accident almost caused Judge
FRA,
Martineau in a breath test of .197.
all right, Esteban,
Thank you, Judge. Esteban, Mr. Vasquez is 28 years old. Judge, he does live in Cincinnati with his partner and their 10-month-old son. Judge, he works at a factory. He's been working there for 4 years. Judge, I showed no local record, 0 failures to appear. I believe this is first lifetime OPI offense. Judge, I did advise him he is not permitted to drive at this time. He does understand that, and with that, I would ask for an OR.
from the state,
Your Honor, there is an ALS in place. Again, this was a pretty high test, .197. We'll defer on bond.
OR plus no alcohol is a condition of bond.
Thank you, Judge.
Garcia,
Garcia.
Robin, Quincy, Robin.
Well, Your Honor, we'll lay probable cause.
is there anything from the state? There's 2 felonies, 2 misdemeanors, 0 failures to appear. She turned herself in on this from June that was related to a pending charge that's already moving its way through.
We'll defer, Judge.
OR.
Thank you, Judge.
Boyd,
Grand jury.
Grand jury on that last one will be 8:31.
You say 8:31?
Yes.
Thank you.
waive probable cause.
Yes, Your Honor.
Thank you.
Not guilty on behalf of Mr. Boyd.
Esteban,
Esteban, Your Honor, we're asking for OR EMU or a low bond, and here's why. This is alleged to have happened in April. Mr. Boyd has no felony record. He has a very nominal criminal record from what I can see. 0 felonies, 0 violent misdemeanors. There are some minor misdemeanors on his record. He is a single father to a 7-year-old son. His son starts school on Wednesday. The son's mother is deceased. So it's just Mr. Boyd and his son. Right now, his mother is taking care of her son, but it's not sustainable long-term. Mr. Boyd also has some health problems going on, has some, he has Bell's palsy, and he also has some dental issues that need to be addressed immediately. But most importantly, Judge, is that he is a single father to the son, that this event happened, this alleged incident happened in April. He's had no issues since, he has no history of violence. And so we are asking for EMU or some kind of lockdown EMU so that he can get his son to school and continue to care for his son.
in the state.
Your Honor, the state would be asking for a high secured bond in this case. The allegations are very serious. The defendant shot the prosecuting witness in the stomach with a firearm. The victim did have to go to the hospital for further treatment. When officers arrived, he was in and out of consciousness due to his injuries. While this did happen in April, the main reason is the defendant wasn't on the scene when this happened. They had to find him, they had to determine who did this. They were able to determine that that was Mr. Boyd. That's when this arrest happened, Judge. There was a third-party witness to this incident, as well as surveillance footage that shows the incident. I would ask for no firearms as a condition of bond, as well as, again, a high bond in this case due to the seriousness of the allegations.
50,000 secure plus no firearms. Davis,
Grand jury warrant that will be 825.
Davis.
Good morning, Judge.
Your Honor, I do have a request for a protection order in this case.
Judge, she will be signing the protection order. Judge, we'll waive PC and just ask you regarding bond. Judge, so regarding bond, first of all, Ms. Davis she's a graduate of Cincinnati State, Judge. She is currently employed working at Opinion Honda. Before that, she was assistant manager at Donald's, Judge, so she's consistently employed. As it pertains to the charges, I guess, we are waiving PC, but I do believe it is overcharged. The paperwork's filled out as F1. For my reading the statute, Florida is an F2, this is a police officer, so I don't think that's applicable. So I think bond should be set according to the F2, Judge. Ms. Davis resides alone with her child. She's a sole provider. 4 of those, 7-year-old child, Judge. She is the sole provider for that child. That child is not with the prosecuting witness in this matter, Your Honor. Nor is the prosecuting witness on her case, Judge. Again, she lives independently with her child, provides for her child. She denies any wrongdoing here, Judge. I just draw the court's attention to her shoulders, both on her collar and on the side, Judge. She was attacked by the prosecuting witness in this case and picked up a knife, and then the police were called. So we will be filing a notice of self-defense. Reviewing her record, the last time she was charged with anything even remotely violent was a misdemeanor assault, and that was back in 2009, and that was dismissed. But since then, she's had some minor charges, Judge, but nothing violent, and she's never been charged with violent felony offense, whether that resulted in conviction or dismissal. Judge, she's going to come to court. We're asking the court for a low bond from the states.
state.
Your Honor, defense counsel is correct in stating that this should be a felony of the second degree. The complaint does say a felony of the first degree, but it should be a felony of the second degree. In this case, the defendant and the victim were in an argument over a woman that the victim, or that the defendant found on the victim's phone. This argument led to the defendant grabbing a knife and wielding it at the prosecuting witness. The prosecuting witness tried to grab the knife out of her hand and was cut on the hand as a result. We'll defer on bond, Judge. Or I apologize. We would actually ask for a monetary bond in this case, just based on the facts. I would also ask for a stay away from the prosecuting witness.
10,000 secure plus jurors if requested. Stay away, no contact.
Carry on at 826.
Kenneth Brown,
We found no probable cause on that. Look here this weekend.
Michael has a letter from Mr. Brown. Whether or not they complete.
Esteban.
Esteban, Your Honor, Mr. Brown's a lifetime resident of Hamilton County, Cincinnati. You can see from his record, he has very little record, no failures to appear, Your Honor. We will be filing a notice of self-defense in this matter. He was attacked by 2 other individuals. He's attended Taft High School. He's working as a parts runner for Joseph Chevrolet. He's been off due to medical leave and recently was released by his physician to go back to work. They're expecting him at work today. He has a sister and a brother here in town that have separate residences, he can go to live at either of those two residences and avoid contact with the other individuals involved. Your Honor, I would ask for OR bond under those circumstances.
From the state,
Your Honor, there are two different victims in this case. They are both the victims of the assault charges. I would be asking for a stay away, no contact for those two victims. And we will defer on bond on the remaining charges.
there's no record except for minor misdemeanors to 0 failures to appear and no weapon, is that correct?
That's my understanding, Your Honor.
There's no allegations of a weapon, Judge.
OR plus stay away. On the B menacing charge, the court, it'll be OR, but the court found from the complaint that was read that there was no probable cause. All the complaints say the exact same thing. Now that I have the packet, I'm assuming that the menacing is alleged to be against the officers, but the actual complaint just says what every other complaint against the two PWs say. So just to make a clear record on that. All right, OR.
Thank you, Your Honor.
Golf.
Let's go right here. You're right with me.
Good morning, Judge. I am designating Zachary Pump, but I will be representing Mr. Goff this morning for bond.
All right, Esteban.
Yes, Judge, as to bond, Mr. Goff has a very limited record. He has only one failure to appear. He is currently looking for work and lives with his dad. I have good contact information for Mr. Goff. He is interested in treatment. He's already talked to one of our social workers in the back about going back to Cat House, which he has previously been at, Judge. We would be asking for an SOR bond. He has split custody of his 9-year-old as well.
From the state.
Your Honor, this occurred in a bar where the defendant grabbed two different victims in a sexual manner through their clothes. I would ask for a stay away in this case as well as a monetary bond.
And Judge, it's my understanding from Mr. Goff is that he has been 10 months sober and had a relapse, and that's why he's interested in getting back into treatment, and that's why he wanted to talk to one of our social workers. This is not normal care.
There is 1 violent felony, 1 misdemeanor, 2 pending alcohol-related charges, 1 prior failure to appear on the disorderly conduct, OR. $2,500 anyway on each of the impositions.
And just for the record, Judge, I have on the trial paperwork, he does not have any felonies, it's a violent misdemeanor.
Did I say felony? It's
Yeah.
1 violent misdemeanor,
Okay,
1
I just wanted
misdemeanor.
to,
And no alcohol plus TAD is a condition of bond.
would the court be open to OR EMD as an alternate?
No.
Thank you.
Pollitt,
He's walking. For sure back in. You walked in Brown.
and then he did.
Good one.
What number?
Your Honor, it looks like there was a prior in 2016. There was also,
This is the third in time.
It's second. Two of the other threes reconciled.
yes, the one from 2013 and the one from 2012 looked like they were reckless operation reductions.
No, I have a, this is Pollitt, right? I
Yes.
have a 20 from November 30th of 2016 OVI conviction and November 27th of 2017 from Kentucky.
I only have local records, so I only have the 2016.
I didn't know that outside.
That's what I have per pretrial, is that this is the third in time.
But Judge, with that said, we'll have to check out the Commonwealth's records to see what's going on over there. This was a walk-in. Mr. Pollard has posted bonds that were given. We would ask that he let him remain out on those same bonds. He understands he can't drive. He's under 45-day bond right now, at least. Now, if it's a third, we got a different situation. The car he was driving was not titled in his name.
Was there an accident?
No accident. FRA was marked no. It was a refusal. And there is an ALS in place.
FRA?
Marked no.
Is this suspected drugs or alcohol?
I believe alcohol does.
There's no prior record, no failures to appear. The A will remain the same cash bond. The B and C will remain the same. I am adding a no alcohol order plus a TAD unit. Mr. Pollitt needs to go over right now to have the TAD unit put on at 800 Rockland.
Judge, you had the CRB number included in that.
Correct,
I just want to make sure.
yes, those were all a warrant. All right, I have a warrant.
Court is in recess. The city domestic. Good morning. Is city domestic next?
Okay.
No, because it's usually not there. So they gonna switch it up. So I'm like, wait a minute now, what we doing?
Sounds good. We are creatures.
Can we add an early call to the minutes?
Who is it?
It's a misdemeanor, so Keisha Dixon.
Where's she at?
She's locked out. She turned herself in.
No, what's that?
County walk-up,
County.
right?
I have another child named after you.
Last name Dixon.
Dixon, yes.
Takesha.
Yes, ma'am.
I went right through it.
Thank you so much.
Will, did you get the paperwork from?
I did not.
Plays a lot, yeah.
Yeah.
My wife goes to,
I
she's
go
gonna take
by.
her to St. Louis. See what, on 6-5. So she's gonna have all of them there, except for 3, they throw the name.
How you like
Then
it?
they found out that I was staying home, so 3 of them.
Oh, different ball game, Come on in.
So,
I love you.
Come here. Mother-in-law, 2 kids. 5-year-old.
It is. But that's okay, look.
So all them went, just so one. I don't know, 16.
I need a juice. She got her water.
They're close. I like it.
Hmm.
She's-
That's why I don't feel
A bunch of them.
Hey, it's gonna be a long week.
Hopefully Monday will be the worst, the storm maybe will help.
It ain't, no.
I'm trying to be positive. Okay,
I'm really positive because see, if you believe that it's not, and then,
that's true, that's true.
then you gonna be in here like,
If we get some really bad storms, maybe.
it's supposed to, well, they said the temperature's supposed to drop like 10 degrees.
I don't know if that'll keep people from being outside. Maybe it'll make more.
I think the fall is coming fast, cause I think this gonna get bad. Because when you come outside at night right now, it's like cool. No.
That's true. Assume the worst, and if it's better than that, then it's a good week.
We only got 2 days next week. Cause she go on vacation, I think, Thursday.
Is it Monday or Tuesday?
And then we have church court Wednesday, and then she's on vacation. I think. Yeah, I think so, because, yeah, it's only 2 days.
So you're gonna do it very small? They don't early before we walk. Yeah, they are.
I don't think so, but somebody tried to put one in.
Yeah, Very good. Okay.
Oh, okay. Yeah, okay.
That was listening, but then so you said judges.
We have change court on Wednesday, Thursday, Friday, and then through the holiday. So I think
So just like.
so. If it is a they only got 2 days to do it or change it.
So what else?
I looked at my email, somebody did submit something, but I'll be able to look at it more when I go over it.
What's going on?
So it was.
Kind of busy.
She goes,
Down there.
so she goes live. So then everybody.
He's on YouTube?
Right now,
What's the channel name?
Janae Barber Brad. Janae Barber Brad.
I always watch the judge out of Harris County, Texas. He does his arraignments and stuff.
Yeah, because they were going through that thing, it was a lot of people not understanding what happens in here.
I opened it.
Still good? What you thinking? No, still with it. Still with it. Hey, great.
Just a.
No, she's locked up. Dixon. Yeah. They're gonna do it next, Will?
I think so. She pulled the paperwork.
Where's she at? Felony or misdemeanor?
This meeting.
Has she ever dismissed it?
Dixon.
Without probable cause? Like
Page
judge in
4.
Harris County, Texas.
8-4. Every now. Every now.
Judge Fletcher. Judge Fletcher here right now. You had that enough.
It was easy.
No, I guess when you in here and you do it, you find some things that are interesting, but then you try to. I guess when I go out of town, I see a lot
We
of
always give side.
different courthouses.
You want to make us already big hat record?
Mhm.
How long has she had her?
Since last year.
Where?
Every time she come in.
I might be on it.
Yeah, you are. From when you were on that side. Yeah, you are.
That marathon in
Oh, yeah.
I had on there, when I was like,
Wow.
18, cruising at 2 o'clock. I worked it all week.
Court is back in session.
Dixon,
Bill Welch on behalf of Ms. Dixon.
all right. Esteban,
Good morning, Your Honor. Ms. Dixon, she is a graduate, college graduate, has a nursing license. She turned herself in on this. She was unaware of this. When she was notified of it, she turned herself in immediately. She's ready to address it. Not sure what's going on. Apparently there was a fight at BW3's, but she is ready and prepared to address this. She is certainly not a flight risk nor a danger to the community.
from the state.
Your Honor, it looks like the defendant was eating at BW3's. She was unhappy with the meal she got, did not want to pay. There was an argument with the manager. The defendant then threw her tray of food at the manager, striking her in the head. I would ask for a stay away from BW3's as well as the manager in this case.
No problem, no objection to that, Your Honor. She also has 2 minor children at home, age 17 and 16.
And what is she doing on the 2 traffic?
Your Honor, we would just like that to go on. She'll address it.
No,
Those will be the same bond. OR EMD plus juris on the assault.
Your Honor, on the jurors, if they can't get a hold of the manager, or if requested, okay.
Yes.
Thank you.
Baker,
Tina Donsford in the courtroom. Tina Donsford, there is a request for a protection order.
Ms. Baker?
Good morning.
good morning.
Elizabeth Sanders for Ms. Baker, not guilty to Ms. Baker Touch.
All right, Esteban,
Esteban, Ms. Baker is 64 years old. She has nothing on her record since 1998, 0 failures to appear in an arrest score of 1. This is a situation in which I will be filing a notice of self-defense, Judge. She was attempting to clean her residence where she has allowed her sister to stay for the last few months. And her sister does have some different issues going on, and her sister became agitated at the cleaning and tried to pin Miss Baker in with a walker. And it ended up with Miss Baker trying to free herself in that situation. Miss, she was in the process of falling, and there was a scratch that occurred. Your Honor, this is a case where her sister does have another place she can stay with her sister's daughter. This is Miss Baker's residence where she's been for over 20 years. I would ask, given the Miss Baker's lack of history, to consider an OR or SOR in this matter.
Did she sign the protection order?
She will.
This is her right here.
Judge, as you heard, the victim in this case is the defendant's sister. There's visible injury on victim when officers were on scene, and this defendant has a prior felony conviction.
OR plus jurors if requested.
Thank you, Judge.
Derek Ellis.
So,
Ms. Jones, OR plus jurors.
Mr. Ellis is represented by Brian Davis. I am representing him.
From the state. Go
Oh, I'm
ahead.
sorry. Mr. Ellis is 23 years old. He is currently, he's been at Taco Bell for 6 years, a shift lead for the last 2 years, and at his current location for the last 2 months. He does have a child. He helps support a 1-year-old. This came about because his ex was trying to have him take care of his son as Mr. Ellis was trying to leave to work, and she showed up at his residence, and because he couldn't take the child because he was going to work, this resulted in a call to police as kind of retaliation. I would be asking, he's had good contact with Mr. Davis, his attorney. He did have another, he's supposed to be in court today, in fact, in front of Judge Peck. I would ask for SOR or OR.
City is requesting a high bond. He has a pending domestic violence case. The court ordered him not to have contact with his victim. Not only does he have contact with the victim in violation of the court order, but he threatens to harm her.
There's 1 prior misdemeanor, 1 pending, 6 prior failures to appear, 5,000 anyway, plus EMD plus jurors if requested. Flowers,
Is Edward Bergen in the courtroom? Edward Bergen, there is a request for a protection order.
Flowers?
Elizabeth Sanders, Ms. Flowers, not guilty. Ms. Flowers.
Esteban.
Yes, Esteban Ms. Flowers is 31 years old. She works for Miracle Healthcare, where she's a caregiver. She's been there for 1 year and 6 months. I think importantly, especially in this case, is that there is a pending assault against the prosecuting witness in this case. He's not yet been assigned an attorney, but the prosecuting witness in that case is Ms. Flowers. She in fact informed me that she was not even notified when he was released or on the next court date at this point. This was all came to a shocking surprise, is not the right word to her though. She was at work when this allegedly occurred. She has 0 failures to appear, very little history, an ORS score of 1. She is absolutely fine filling out the TPO. In fact, he has a stay away where he is not supposed to be contacting her right now. She has no desire to be around him. He did assault her previously. This isn't even a self-defense claim. This did not happen. He is upset about being charged with the assault that did occur. With that, with the TPO, I would ask for Ms. Flowers. Additionally, she does have 6 kids, Your Honor, ages 5 to 12. She's a single mom. They all start school on Wednesday. I would ask for an SOR or OR for Ms. Flowers.
From the state.
Judge, the complaint says that this defendant punched the victim in the face, scratched his neck, visible injuries when the officers were on scene, and the fact that there's a pending case involving the same parties just indicates that this court needs to issue an order to keep them apart.
Ms. Flowers has no record except for 1 minor misdemeanor, no failures to appear. She's executed the TPO, correct? OR plus the TPO.
Thank you, Judge.
Huff,
There is a request for a protection order. Is Olivia Johnson in the courtroom? Olivia Johnson.
Thank you. Not guilty for Mr. Huff, Judge.
all right, Esteban.
As to bond, I would note Mr. Huff, he is 44 years old, has 0 failures to appear. He currently resides with his mother, who he full-time takes care of. She has aphasia, she is paralyzed, has strokes and seizures. He lives with his mother and takes care of her. He is now the only child. His sister passed away. He also cares for his sister's 10-year-old daughter who mom has custody of, so they all live together. As part of taking care of mom, he is employed through Mamba Health Care. He went to Fortis as a welder. He came with a welding degree, but once his mom began having physical and mental issues and he needed to take care of her full time, he did have to stop that work. Mr. Huff is going to execute the TPO. He does not live at the same residence as the prosecuting witness. He also has 0 failures to appear in the last 5 years, Judge.
Judge, the domestic violence complaint alleges that he pulled the victim's hair in an attempt to cause harm to him. The resisting is that he pulled away from the officers. Thank you.
There are 10 violent felonies, 3 felonies, 3 misdemeanors, 0 prior failures to appear. The standard fine will remain on the A and the B. And that's the last felony was in 2018. $2,500 anyway, plus juris if requested. On the C. Summers.
Michael Lancelot for Mr. Summers, Your Honor.
All right, Esteban.
Not guilty, Esteban, Your Honor. Your Honor, Esteban, Mr. Summers is, he's a lifetime resident, he's 52 years old. He operates as a contractor. He's employed in that capacity. He also has part ownership in a business that I'm told the complaining witness showed up unexpectedly. He indicates that he is allowed to text her as it relates to their one child. It was also important that he let her know that he was part owner of that facility and that she could not be present there. Your Honor, he's at no risk to the community in general, no risk to this individual. I don't believe any threat or attempt to harm was indicated by the police. I would ask for a war bond.
From the state.
Judge already ordered that he not have contact with her. He violated that order. You see, he has a significant criminal history, including prior protection order violations and felony convictions. This court should issue an order that protects this victim.
Your Honor, it does indicate to me that this specific alleged victim has made allegations in the past that he's been acquitted of.
There are 7 felonies, 4 misdemeanors, 3 prior failures to appear, 1 pending charge for a TPO violation. $2,500 anyway, plus juris if requested. Upshaw.
Honorary Jones in closing, Honorary Jones. Request for protection order.
Michael Lancelot for Mr. Jones.
Come in right here.
Not guilty, Your Honor.
All right. Esteban.
Esteban, Your Honor, he is a lifetime resident of the city of Cincinnati, Hamlin County. He is employed as a forklift operator. He pays child support for his one child, Your Honor. He does have an alternative address, and he's willing to sign a stay-away order.
From the state.
Judge, the allegations are that the defendant threatened to kill the victim and scratched her eye, causing physical injury. I note the record shows one brother. We ask for protection.
I have 1 prior felony, 3 prior failures to appear. $2,500 anyway, plus juris if requested with the TPO.
Yes.
Maria Young,
Is Haley Young present? Haley Young. No. Protection order.
thank you.
That last time.
Not guilty, Your Honor.
All right, adds to bond.
As the bond, Your Honor, the alleged victim is the sister of my client. She's homeless, and Ms. Young has been helping to take care of her from time to time. That individual is residing in a shelter. It's really a good Samaritan type situation, Your Honor. She had been, as I said, caring for her sister. Her sister got upset because there are limits to what an individual can do for another. And at that point, my client was assaulted. She has staples in her head from the violence that her sister inflicted on her. I don't believe there was any injury shown by the sister. Your Honor, she's been locked up for 3 days. She has live pets at home. The sister does not live with her. And as far as we know, is back in the shelter. My client had ongoing critical medical issues prior to this incident, and she has not received the medicine that she requires to maintain her health. In addition, Your Honor, due to the assault that was inflicted on her, she has staples in the back of her head that have to be treated and at some time removed. Your Honor, I would ask for an OR bond at this time.
That is my nephew, the one that, she was, that's her kid.
You have no trouble staying away from her. Exactly. She'll sign the TPO.
From the state, on the OVI, what number is this?
First in time.
I'm sorry,
First in time, Judge.
first overall as well?
I don't know.
Yes.
All right. Is there an accident,
No accident, Judge.
test, or refusal?
The refusal, Your Honor.
FRA?
Indicate what she has and show the chart.
And ALS?
We don't have a copy.
From the state?
Judge, on the domestic violence, the allegations are that the defendant grabbed the victim by the hair and punched her multiple times. This is her sister. We asked that she sign a TPO.
She has, Your Honor. And
Judge, I'm sorry to interrupt you, but it's clear she doesn't come to court by the number of cases. She has multiple cases where she has repeatedly failed to appear. The bond should reflect that.
I have two failures to appear, Your Honor, that's all. And I would point out that she's unable to make a cash bond.
All right. On the OVI, you said there's not an ALS in, so you don't know if there's one?
Correct. It's not in the jacket.
So the court will impose a public safety suspension in the event there is no ALS. It'll be an OR plus no alcohol plus TAD. On the reckless, OR no alcohol plus TAD. On the DV, OR plus no alcohol plus TAD. There are two prior failures to appear, no other record as an adult or juvenile, except for one minor misdemeanor. There are two cases though. On the minor misdemeanor pedestrian violation, it'll be the same bond or alternative OREMD. On the menacing, it will be the bond that the trial judge set, which was $5,000 anyway. Harris.
Right up, Mr. Harris, I hear your wonderful attorney's gonna be up here in a second.
Elizabeth Sanders for Mr. Harris, not Joseph, but Mr. Harris.
All right, Esteban.
Esteban, Mr. Harris is 47 years old. He does currently reside with his mom. He's also connected to GCB for a number of services. He's provided me with the name of his caseworker there at GCB. He does deal with several different mental and physical issues that he takes care of by staying on a plan with GCB, including different medications. He's from the area and he went to Taft High School. His whole family's here. I would ask you to consider an OR, SOR, or an alternate OR EMU on this matter, Judge.
From the state.
Judge, this is a misuse, temporary use of theft using credit cards. They're receiving stolen property using credit cards. I do know Mr. Harris has somewhat of a lengthy record, and he looks like he's been found incompetent.
I have 2 violent felonies, 1 violent misdemeanor, 8 misdemeanors, 3 prior failures to appear. It will be the same standard bond, which is $2,500, or alternative OREMD. Jonathan Sester.
Thank you, Judge.
Left hallway, Mr. Harris, 10 minutes.
Michael Lancelot from Mr. Sester, Your Honor. He is going to plead guilty to both charges.
What? I'm not doing a 1 credit 1, so if.
I had asked for that, the state is not willing.
No, I am saying I am not doing not a 1 for 1. I'm saying I am not doing a 1-day credit 1 day.
I see.
This is a M2. So you can plead if you want to, but it is not going to, there are 17 prior misdemeanors and 9 failures to appear.
He still wants to plead, Your Honor.
Okay. Mr. Sester, a guilty plea is a complete admission of guilt. The possession of drug paraphernalia is a misdemeanor of the 4th degree. Maximum possible penalty is up to 30 days in jail, up to a $250 fine plus cost, and a possible period of probation. The possession of drug abuse instruments is a misdemeanor of the 2nd degree. Maximum possible penalty is up to 90 days in jail, up to a $750 fine plus cost, and a possible period of probation. You have the right to a trial to the court, to a jury trial, to have your attorney call and cross-examine witnesses, to testify or not testify, and not testifying would not be used against you. If you are not a citizen of the United States, you are hereby advised that a conviction of the offense to which you are pleading guilty could have the consequences of deportation, exclusion from admission to the United States, or denial of naturalization pursuant to the laws of the United States. Are you under the influence of anything that would stop you from understanding what I've explained? You understand the 2 charges, the maximum possible penalties, including that you could be charged or up to 90 days on one, 30 days on the other, and those could be run consecutive to one another as jail time. You understand that? And you still want to plead guilty today, even though you have the right to a trial?
Yes, ma'am.
Counselor, do you waive and stipulate?
I do, Your Honor.
Finding of guilty, mitigation.
Your Honor, my client concedes that he has a drug issue. He does want to he does wish to take this opportunity to sober up, and he's looking to continue in a program once he's released, Your Honor. I don't believe that it serves justice or the safety of the community to hold him for an extended sentence. I would ask that he be given time served. You've indicated that you would most likely not do that. I would ask for a minimum sentence.
From the state?
Judge, if you're familiar with his record, we appreciate it. He pled guilty. We'd ask you to impose your appropriate sentence.
And how many days credit are there? Is there 3? He was picked up on the 14th.
I believe that's the case, Your Honor.
All right. Mr. Sester, did you want to say anything? You have the right to, but you do not have to.
Just that I took this time to get in the MAP program, and I just took the initiative myself. That's it.
On the possessing drug abuse instruments, 90 days, credit 3, remit the fines and costs, no 2-for-1, no 3-for-1, no early release. It will run consecutive to the possession of drug paraphernalia, 30 days, credit 3, remit the fines and costs, no 2-for-1, no 3-for-1, no early release. The reason for the consecutive sentence is that there is 1 violent felonies, 2 felonies, 17 misdemeanors, 9 prior failures to appear. It appears that community-based treatment is either not working or Mr. Sester is not availing himself to it. The court is immediately making Mr. Sester eligible for treatment in the jail's care pod. If he is eligible for that treatment, if he successfully completes it, then they'll file a motion to mitigate him out early to the trial judge. But I am ordering jail-based treatment if Mr. Sester will avail himself to it.
Quarter to recess.
You get tax breaks millionaire. Be able
Anytime you're in a room, I love all the girls that you have. It's always so cute. Yeah, and the people that were aged by the stuff. Did you see that?
No, but I've been seeing it in here though.
Okay.
But I don't know, unless they're misdemeanors.
They might be on this wall, so.
Oh, city, yeah, misdemeanors.
I mean, I think there's 3 fights on Friday, maybe Saturday.
Yes.
Court is back in session.
There's a high bond request on that one. K,
Okay. Okay, young man, right up here, full attention.
Good morning,
good morning, waive probable cause.
we do, Judge, just for the record, designated for Dallas Governor, but Chris Coleman standing in, she's in trial.
All right, thank you.
Judge, we plead not guilty, we waive probable cause. Regarding bond on Mr. Case, Judge, he attended Elder High School all the way up to the 12th grade. He is currently employed, he's working at a barbecue chicken restaurant near downtown. I'm only showing one failure to appear, Judge. With his income from that job at the chicken restaurant, Judge, he raises 2 children on his own, ages 2 and 4. As it pertains to these charges, Your Honor, he indicated to me that he had been attacked by the individuals involved in this matter prior to the alleged gunshot. Judge, looking back through his record, he does have some charges, but nothing particularly violent. I think the last time he had an assault conviction was a misdemeanor 10 years ago in 2016. Judge, so we're asking for an OR bond.
From the state.
Your Honor, the defendant in this case fired a shot at another person. It's my understanding that the person was not struck by the gunfire. However, these are very serious allegations. The defendant does have multiple prior carry concealed weapons convictions. Based on that, I would ask for a high monetary bond in this case. I would also ask for no firearms as a condition of bond.
There are 4 prior felonies, 3 violent misdemeanors, 12 misdemeanors, 1 prior failure to appear. $25,000 secured.
Jury report 825.
Curtis, there is a common order.
Good morning. Again, Judge, is Chris Coleman standing for this government.
Waive probable cause.
We do.
Ask the bond.
As the bond holder, so we're asking the court to consider electronic monitoring. It's a low-level drug charge here, Judge. We have had social work involved to assist Mr. Curtis around. We're hoping to get him in the cat house.
From the state.
Your Honor, this is an at-5 possession of cocaine. We'll defer to bond.
There's 9 felonies, 4 misdemeanors, 14 prior failures to appear. On the bicycle violation, OR. On the possession, F5, 2,500 anyway, or alternative OR, EMD.
Jury report will be 825.
Deaton.
Together.
Yes, everything will be reviewed.
And a high bond request.
Go back.
I'm submitting Luis Suarez's designation for Mr. Deaton. The felonies are appropriate for drug court, two-way probable cause. Thank you. Judge, he reports full-time employment doing maintenance for CMHA. He has a stable address on Work Road. You're setting bond on two fifth-degree felonies, and he is going to be offered treatment, so we'd ask the court to take all that into consideration.
From the state.
The state will defer, Judge.
He's on state again, right?
Yes.
There's 2 violent felonies, 10 felonies, 1 violent misdemeanor, 11 misdemeanors, 12 prior failures to appear on and there is a request for a high bond from the officers based on their continued contact with Mr. Deaton stemming from his alleged addiction. On the felony, 2,500 anyway. On the A, on the B, 2,500 anyway. On the C, 1,000 anyway, or alternative OR and D. On the B misdemeanor, 1,000 anyway, or alternative OR and D.
Grand jury report is 826.
Frederick.
Is that on everything?
826.
Morning, Judge.
Good morning. Waive probable cause.
We waive probable cause.
As to bond.
As a bond judge, I begin by noting Mr. Frederick served was an honorable discharge from the Army. He was enlisted in the years of 1997 to 2001. Judge, at this point in time, he now lives with his wife and their 13-year-old son in Hamilton. It's a stable residence there, Judge. As it pertains to the charges, he indicated that they have an individual residing in Oakland State in the garage. It's a former co-worker of his who was homeless, stood fighting with place to stay. That person also drives the vehicle that was allegedly involved in this incident, Judge. As it pertains to the charges themselves, I note that the highest level offense, the tampering, Judge is effectively allegedly having the property that's stolen on the property of their home. So I don't really know, like, logically, it seems like it's impossible to commit the theft offense and then not commit tampering if tampering is simply having the property on your premises, Judge. But again, Judge, a veteran with an honorable discharge status, children will keep the eyes for the judge. We're asking the court to consider it a one bond.
From the state.
Your Honor, the defendant in this case took a shop vacuum from Tri-State Outdoor Equipment. I would be asking for a stay away from that location. He also was found with a stolen license plate on his vehicle. It looks like the tampering of evidence is based on hiding the vacuum in his garage. Again, I would ask for a stay away and we'll defer on bond on the remaining charges.
There are 2 violent felonies, 9 felonies, 4 misdemeanors, 2 prior failures to appear. On the misdemeanor, possessing criminal tools, 1,000 anyway, or alternative OR and D. On the tampering, F3. $2,500 anyway. On the F5, receiving stolen property and breaking and entering. 1,500 anyway on each, plus stay away from, where is this at, Tri-State Line Equipment. All right, what's the grand jury date?
8/26.
Howard, what's the high phone?
What was that, right?
Good morning.
Morning, Your Honor. Thank you. Your Honor, we would like to hear a reading of probable cause, please. The felony, yes.
Say on or about August 15th, 2026, in Hamilton County, state of Ohio, the defendant transported a loaded firearm in a motor vehicle. It was a Chrysler PT Cruiser. He had the loaded firearm in a glove box. It looks like he also has an active protection order against him, which prohibits him from having firearms. He did not disclose the firearms when officers asked if there were firearms in the vehicle.
Your Honor, although not mentioned, there was a passenger in the vehicle. I'll also note that the protection order at issue, box 13, which states respondent shall not possess, use, carry, or obtain a deadly weapon, that is not checked in the protection order. So I would ask the court to find at least that there was not probable cause for the BPO charge.
Do you have a copy of it?
Yes, Your Honor.
Can you show it to the state and then show it to me?
Yes.
That's all we got, we don't.
What can I help you with? I do not. I'm not.
Hold on, let your attorney speak for you. Thank you.
Thank you.
Does the state have anything as it relates to, we'll go into the others, but as it relates to the protection order, I'm trying to find my complaint.
Judge, I don't know if I mentioned before, he does have a prior protection order conviction, which is why this was charged as a felony. However, I do note that box 13 is not a fact on the protection order.
You're on.
So on the violation of a protection order charge only, based on the complaint, the court finds probable cause. That is more of a defense. So there will be an OR bond, but the court finds probable cause based on the reading. And I will note that was issued, defendant not prohibited from possessing them as boxes 13 and 14 were not checked. All right. Are you challenging probable cause on everything else, or was it just that one?
It's on the gun charges, the judge, I just noticed there was a passenger in the vehicle, but we'll submit on that.
All right, probable cause on those. As to bond,
Thank you, Your Honor. As to bond, Mr. Howard's 41 years old, Judge. He's got a family. He's married for 5 years now. He's got 5 children living under his roof. The youngest is 9 years old. Your Honor, the biggest thing for him today is he just started a new job with Universal Transportation Services. He's been there for a few days now. He passed his assessment on Friday, supposed to start his actual routes on Wednesday of this week. He tells me he cannot miss more than 4 days of work or he's basically fired. This is a super important job to him. He's very passionate about it and he's anxious to get back out and get to work. Your Honor, I think the court can see no felonies for Mr. Howard, no convictions. His last misdemeanor was that violated protection order back in 2017. That involved his ex-wife. They don't have any contact since. They share a couple of children together, but that's the extent of it. This is someone that hasn't been in trouble, Your Honor. Just briefly, I want to note, my client was DDing basically. He picked up his wife who had been drinking. She had an open container in the vehicle. She also told the police in this case that the firearm was hers. It had been in her purse. At some point, I guess she moved it to the glove box. I don't know when that took place. But she told the police officers this, and this should be on body cam, and the police officer said, well, we're charging your husband. So I think we will have defenses to these charges. Again, he's not someone with prior felonies, not someone that is gonna be a flight risk, Your Honor. He would like to just get back to work. He tells me finances are really tight right now. So I have to ask for an OR bond. If the court won't consider that, I'd ask for something reasonably low. Thank you.
from the state.
Your Honor, these allegations are serious. There was a loaded firearm in the vehicle that Mr. Howard was driving. He is not permitted to carry a concealed weapon based on a prior domestic violence conviction. He was very uncooperative with officers when they pulled him over. I would ask for a high bond in this case, as well as no firearms as a condition of bond.
Judge, can I add one thing? I want to make sure this is heard. I know you already set bond on the VPO, but he never received an actual copy of that protection order. He was adamant about that to me in the back, saying he didn't have notice, never received a copy of it. I just want the court to know that, but again, he's not having contact with them.
So the basis, there's 1 violent misdemeanor, 3 misdemeanors, 15 prior failures to appear. The basis of the CCW and the improper handling are transporting a loaded firearm in a glove box, which the glove box was searched without permission based on finding an open container in the vehicle. And per the complaint, it was having it in the glove box while having an active protection order and a previous conviction for a violation of a protection order. I don't have a previous conviction, and we've already established that the current, do you have the date of a previous conviction?
Yes.
I have acquitted, dismissed,
I
the
have
current TPO.
one from 2016, the case number is 16 CRB 15254.
Hold on, give it 16 CRB.
15254.
All right, let me, it's not listed on this one.
Looks like the sentence date was August 7th, 2017.
Here it is. I see it here. It's just not on my information here. All right. On the A, 2,500 anyway plus EMD. On B, 1,000 anyway plus EMD. On the misdemeanors, OR, the EMD is because there are 15 failures to appear. It's open hours, the EMD, so it should not be an issue with him being able to work with it on.
Grand jury report will be 825. That's for everything except for.
There's no, all of the misdemeanors go except for that. There was a KPS.
Yes.
That was so that one is changed to OR. That was a magistrate bond set. All right.
How about the 16727? I don't believe.
That's the one that.
That's the magistrate bond, that it's a minor misdemeanor, it was modified to OR.
Leah's not guilty.
Yes.
825.
All right. McCoy. What's your name, ma'am?
Good morning, my name is Janice McCoy. I'm Uncle Edris McCoy's mother. And this incident is between him and my daughter. And my daughter is known to not always tell the truth. And so I think she's just being vindictive in this case.
Thank you, ma'am.
Yeah.
Waive probable cause.
We do, Judge.
As to bond.
As to bond, Your Honor, first of all, I note that Mr. McCoy is signing the TPO as we speak. Judge Hewer made a lot of his mother just said on the record to me after that. And effectively, his sister is dishonest, has a history of calling the police whenever there's familial disputes. Anytime anything goes wrong, she calls the police and makes allegations to deal with those issues. Mr. McCoy denies any wrongdoing in this matter, Judge. He also has an ORAS of 2. As it pertains to employment, Judge, he actually owns a small business, real moving company, verified it online. I believe he employs about half dozen people in that position. He provides his children with that job, ages 10 and 4. He has sole custody of both of those children, Judge. The last time he had a family conviction was nearly 2 decades ago, in 2010, or 2010, Judge, and that was for nonviolent offense. Again, I think, Judge, he's reminding me, I apologize, that Mr. McCoy did surrender himself after he was made aware of the existence of the warrant against the elder judge. We're asking the court to consider no one wrong. Again, I think it's pretty rare you see someone's mother come in and speak against their own child at Arraignment. So.
From the state.
Your Honor, these were two separate incidences that involved the same victim. They happened on August 3rd and August 4th. On August 3rd, that was the felonious assault. The allegations are that the defendant punched the victim on the right side of her face with a closed fist, causing her to fall. He then grabbed her by her hair and began slamming her onto the concrete. She did have a very large cut over the right side of her forehead, and she was taken to the hospital for that cut. She also had minor injuries to her eyes, and her eyes were visibly swollen. There were some bruises on her hands and legs as well. Then the next day, on August 4th, the defendant broke into the victim's house while the victim was laying in her bed and assaulted her, punching her in the rib cage multiple times, causing injury again as well. I would ask for a high bond in this case. These are serious allegations. It does involve 2 different days, both with injuries to the victim. So I would ask for a stay away in this case as well, but a high monetary bond based on the facts.
There are 3 felonies, 1 violent misdemeanor, 8 misdemeanors, 2 prior failures to appear. On the misdemeanor, DV 2,500 anyway, plus juris if requested. On the felonious assault and on the felonious assault F2, 10,000 anyway, plus juris if requested. On the ag burglary F1, 20,000 anyway, plus juris if requested.
Grand jury is 826.
Thank you. Morris.
Morris.
The felony and related misdemeanor, I'm submitting Luis Suarez's designation and Ms. Sanders' designation on the unrelated. We can waive probable cause on the felony.
As to bond.
Bond, Your Honor, she is a lifelong resident of the greater Cincinnati area with a stable address on Cooper Avenue in Lockland. My understanding that she has missed some court and that is due to medical issues. She reports having her gallbladder removed recently, and she's also been treated for cancer. The court is setting bond on a 5th-degree felony, and she's going to be offered treatment, so we ask the court to consider supervised release.
From the state.
We'll defer.
There's 1 felony, 1 violent misdemeanor, 9 prior failures to appear.
Can I address the KBS on that?
Yes.
I would just add, in addition to what Mr. White said, that Ms. Morris is she did get her dates confused, and part of that is you can see she has a port in her chest. She has had a mastectomy. She is scheduled to start another round of chemotherapy and have her breast removed, Your Honor. Given she does also have 2 kids that she does try to help support. She is in a period right now in her life where she is trying to address these medical conditions and cancer. I would just ask you to take that into consideration with what's happening with the KBS.
There's OR EMD on everything. The EMD is because of the failures to appear. Steinmetz.
Grand jury, that's 826.
Thank you.
Cool. Now, OR plus EMD, buddy.
Good morning, Your Honor.
Good morning.
We are waiving probable cause and
All right, as to bond.
Thank you, Judge. As to bond, Branson is 18 years old, Your Honor, no adult record, received one prior juvenile investigation, 0 failures to appear in court. He lives in Trenton, Ohio with his mother, Your Honor. He is not currently working. He has worked previous jobs in fast food. He tells me he's trying to finish high school and then go on to earn his HVAC certification. He doesn't have any children. Your Honor, I think this is a situation where a group of individuals maybe made some not so smart choices. I will say, in reading the affidavit of the alleged victim in this case, there's nothing in there about a threat. He says someone basically was hanging out a window with a firearm. My client says he was not threatening anybody. Again, that was not the intention. There were other individuals present in this vehicle. My client tells me he had no issues with the police. He was very cooperative with them. Your Honor, he's obviously underage to have a concealed firearm, and we advised him of that. He cannot afford anything today, so I have to ask you to consider OR. I do think an EMU, he could do that. I think he'd be fine on that, Your Honor, no issues with that.
How far is Trenton?
You know what county Trenton's in?
Butler. It's like a 45-minute drive, but I can make it to work when I need to.
So I think that would be appropriate, Your Honor. We'll submit on that, thank you.
From the state.
Your Honor, I would ask for a monetary bond in this case. The allegations do involve multiple firearms that were found in this car. There are allegations that a firearm was pointed towards all my son's business. There was an admission from the defendant that he was the person who pointed the AR pistol at the business, and then he took ownership for the firearms found in the car. So I would ask for a monetary bond in this case.
The defendant has no record as an adult, no failures to appear. There was a violent misdemeanor as an assault as a juvenile, but nothing else. Is the allegation to a person or to at the building?
Your Honor, I believe he pointed it at the building. I don't have any indication that someone was outside. There is someone listed as a victim who saw the firearm being pointed at the business.
On the ag menacing, OR plus juris if requested, supervised OR on everything else. It looks like those charges are purely based on age.
What was the date on
And no firearms.
No firearms.
I have a warrant.
Grand jury will be 8:31.
Thank you.
Cool. That's all I OR, juris.
This is for the first walk.
Okay. What we doing, county or felony walking?
Felony walkings, yeah. Figueroa and Macia.
Ladies and gentlemen, real quick, they're about to call it 2 names in here, those are felony walk-ins. After that, we're right here, not, those who are locked up in the jail, then those who are cited or paid bond for your identified. And then we have a 10. Who's the other one?
This is one. There's Figueroa, That's real.
Generation, we got my generation.
Court is back in session.
All right. Figueroa,
Yes, Judge, I submitted Stephen Winky's designation. We can waive probable cause if that's necessary, and just ask for a grand jury report date.
all right, the court said over the weekend, OR bond, on the 2 charges, there's 0 failures to appear. Is there anything from the state? She's here today. It'll be the same bond, OR.
Grand jury will be 8:30.
Tiana Mazion,
Wait for me out there, I'll try to answer your questions. Your Honor, I'm submitting Stephen Winky's designation.
Ms. Mazion posted bond. It was $2,500 on each count based on the number of failures to appear. Is there anything from the state?
No, Your Honor.
All right, it'll be the same bond that Ms. Mazion has already posted.
Grand jury will be 8:30.
Okay, so you're done here, but if you have any questions, you can wait for me out there, I'll try to answer. It's August 31st.
Delphon,
Yeah.
Elizabeth Sanders from Mr. Belton, not guilty.
what number driving under is this?
Locally, I don't see any, well, locally, it looks like he has a prior driving under OVI suspension in 22.
So it's second.
I believe that's the only one I see, so it'd be second.
All right, from this, Esteban.
Esteban, Judge. Mr. Belton is 37 years old. He just a few weeks ago started as a quality lead supervisor with Steele O'Brien. They work with steel piping. He also part-time still does personal fitness training. He also is a part-time student at UC. This is his last semester in school. He's studying psychology and is to graduate at the end of this year. He does provide and support 4 kids ages 12, 13, 15, and 17, 2 of whom do live with him, Judge. As to the prior habeas, Mr. Belton did let me know that when he realized he was not going to be able to make it to court, he tried to call, but it was too late at that point. And the habeas did happen, though he did intend to try to reschedule. He also indicated that at that point, he did not have an attorney. He does now. I do have good contact info for Mr. Belton. I would ask you to consider changing the habeas bond, Judge. I do have good contact info for him. I would also note that the disorderly conduct charge, Mr. Belton noted that he had gotten dropped off by an Uber and realized that he left his keys, so did sit down in his yard and wait while he waited for his girlfriend to come home. I would submit on that, Judge.
From the state.
Your Honor, based on habeas material, that's for Ramona and Mary Dawn.
There are 2 violent misdemeanors, 7 misdemeanors, 3 pending charges, which are these, and relevant to the bond setting are 10 prior failures to appear. So there was an explanation for 1. I don't know what happened the other 9 times. On EMD, which could be an alternate to the capious bonds, Mr. Delphine, it looks like has been on EMD 4 times and has been unsuccessful each of those 4 times. 3 times in 25 and once in 24, so I'm not trying that again. On the driving under OBI suspension, it'll be the same bond, which is $5,000 anyway. On the minor misdemeanor, I will modify that bond to $150 from $5,000. On the disorderly conduct, it'll be I'll modify it from the standard bond of $500 to $250 anyway, plus tab, plus no alcohol. Benny?
Thank you, Judge.
Michael Lancelota for Mr. Bernie. Not guilty, Your Honor. Esteban, Mr. Benny is a lifetime resident of Hamilton County, Cincinnati. He works part-time at, on a food truck. He's 59 years old. He resides with his girlfriend on Good Bramwell Road. Your Honor, he is recently sought treatment at D-Coach. He's qualified, and he looks forward to receiving an OR bond so that he can continue the process of enrolling in that program. Submit with that, Your Honor.
From the state.
Your Honor, this stems from a theft from Walmart. I would be asking for a stay away from all Walmart stores. I would also be asking for a monetary bond in this case. The defendant has multiple prior theft convictions as well as burglary convictions, breaking and entering, and I would be asking for a monetary bond based on those priors.
There are 5 violent felonies, 7 felonies, 1 violent misdemeanor, 11 misdemeanors, 3 prior failures to appear. These charges were picked up, it looks like the allegations are from 8/7, 8/14, 8/15, and Mr. Benny was just released on the same charges in July of 2026. EMD, Mr. Benny has been unsuccessful on having the bond revoked on that. I'll keep the standard bonds on each, 1,000 on the theft, 1,000 on the criminal damaging, 500 on the trespass, and 1,000 on the attempt. Those are anyway bonds. Burns.
Michael Lancelota for Mr. Burns, Your Honor. Not guilty, Your Honor.
All right, Esteban.
Esteban, Your Honor, he does have a couple serious felonies, but he relates to me that those go back more than 30 years, 1980s actually. The alleged victim is his wife. She is not the one that contacted the police. It was a sister-in-law who interjected herself in what was a nonviolent situation. He is the breakfast chef at a hotel, one of the hotels here in town. He missed work, I guess Saturday and today, and it's very important that he get out so that he can maintain that employment. He has some college, Your Honor. As I said, he is married, and we'll submit, Your Honor.
From the state,
There was a request for a temporary protection order in this case. It is an M4 domestic violence threat. I would be asking for a stay away from the prosecuting witness and we'll defer on bond.
he executing the TPO.
He is, Your Honor.
As was stated, there are 2 prior violent felonies, but they are very old. There's nothing else, no failures to appear. He's executed the TPO. It'll be an OR bond.
Thank you, Your Honor.
Delaney, there's a photo on.
No, he's OR.
Michael Lancelot and Mr. Delaney, Your Honor.
As found.
Your Honor, I believe you just had the OBI suspension, is that correct?
That's all I have in front of me.
Yes, Your Honor. He does want to dispose of this today and would plead guilty to it.
What number is this?
Judge, I only have his local record, but based on my reading of the local record, it would be a first ever.
That's my understanding as well.
So I don't have his dates, so I don't know if he has any out of time.
I don't have anything else. Mr. Delaney, a guilty plea is a complete admission of guilt. This is a misdemeanor of the 1st degree. Maximum possible penalty is up to 180 days in jail. There is a mandatory minimum on this charge of 3 days in jail. So it ranges from 3 days to 180 days. Fines up to $1,000 plus costs, a license suspension, as well as a possible period of probation. This is an offense that cannot be expunged. It is also an offense that enhances, meaning that additional convictions of the same offense can result in additional more severe penalties. You do have the right to a trial to the court, to a jury trial, to have your attorney call and cross-examine witnesses, to testify or not testify, and not testifying will not be used against you. If you are not a citizen of the United States, you're hereby advised that a conviction of the offense to which you are pleading guilty could have the consequences of deportation, exclusion from admission to the United States, or denial of naturalization pursuant to the laws of the United States. Are you under the influence of anything that would stop you from understanding what I've explained? You understand the charge, the maximum possible penalties, and your rights. You understand that you will be required to serve a minimum of 3 days in jail based on the charge by law. And you wish to waive your right to a trial and maintain a guilty plea to a first driving under OBI suspension. Counselor, do you waive and stipulate?
I do, Your Honor.
Finding of guilty. Mitigation.
Your Honor, he understands the significance of driving without a driver's license, driving under suspension, rather. He understood that the suspension is up in January. He is a college graduate. He works with scaffolding for, I believe it's a construction company. Your Honor, he understands that there will most likely be a continued or extension of his suspension due to his violation, and he would just ask for the minimum 3 days and minimum suspension, Your Honor.
From the state?
Your Honor, it looks like this was a first in lifetime based on the record that I had. Insurance was marked no, there was no accident in this case. We will defer on sentence.
Mr. Delaney, did you want to say anything? You have the right to, but you do not have to. As this is a first, I will impose the mandatory minimums. There was a plea of guilty, finding of guilty, 3 days, credit 1, $250 fine plus cost, 1 year driving suspension effective August 16th, 2026. FRA non-compliance. The fines and costs will be referred to collections. If not paid by March 1st of 2027.
Thank you, Your Honor.
Thank you. Wilt.
Dixon.
It's under this, it's the alias for this individual.
Is this her too? No, Jalen Whitman. No. Oh, Dur and Wilt are the same. Okay.
Here.
Good morning, ma'am. Who is on this?
Yes, the plea would be not guilty, Judge.
All right, as to bond.
Yes, Judge, as to bond, Ms. Durr has informed me that she has completed most of the requirements of probation during the Talbert House and other treatment. What is holding her up is failure to pay, is my understanding. She's on disability and that's why she's struggling so hard with that requirement, Judge. She's a really limited record, only misdemeanor. She hasn't been in trouble since this charge in 2020. We would be asking for an OR bond. I have good contact information for her, and she's still affiliated with Boulder Care, and that's where she's getting her treatment right now.
From the state.
Woodford.
It'll be 1,000 anyway, or alternative OR-EMD open hours because of the number of failures to appear, and that these failures to appear were just from 2 months ago.
Okay.
Goodwin.
Okay. Yep, La Joy, 10 minutes. Gonna follow me out. Now, we're right in the people.
Plea would be not guilty, Judge.
As to bond.
Yes, Judge, as to bond, Mr. Goodwin has a very limited record. There are only misdemeanors on his record, Judge. He works as a home health aide. He has work tomorrow. He is from Cincinnati. It's my understanding he has a separate place to live than the prosecuting witness. It's also my understanding that his father was there during the situation, so there was another witness. There were no visible injuries. He has told me that there is a pattern of this prosecuting witness where if she is unhappy with him, she does call the police on him. There are 2 dismissed DVs on his record as of recently, and that's what this situation is similar to. Judge, we would be asking for an SOR. Also, he is signing the temporary protective order. Is there, and I would, yes, I would ask to remove the child from the temporary protective order.
I'm not going to remove the child right now, only because the allegations are that she was holding the child at the time of the incident.
Okay.
So I will not remove it as to him right now. Hello, sir.
Your Honor, I'm Father Jalen Goodwin. I was there before the police even came. And his child's mother, he called me to pick him up to take him home. That's why she got mad. Because he has his own apartment now. He won't tell her where she lived. She did have a baby in her home, and she stood in front of the door. I was right there at the door at the walkway. She would not let him out. And he had me on speaker, and I asked her, I said, Stacia, why you just won't move to let him out the door? And as soon as I looked back, the police pulled up. I even told the cop, I've been sitting there for 20 minutes. But this certain police officer is not healthy. This girl has called the police 33 times on my son. She has had him arrested 3 times and have never showed up to court.
Thank you, sir.
And he is executing the protective order, Judge.
From the state.
Your Honor, I would be asking for a monetary bond in this case based on the fact that the one legal child of the prosecuting witness was in the arms of the prosecuting witness when she was pushed by the defendant.
Mr. Goodwin has 1 misdemeanor, no record of violence at all, 2 prior failures to appear. It will be a OR bond plus the TPO. He'll be released shortly, sir. He'll be released.
He's getting out.
We got about 1 hour.
We'll talk in the hall.
John Henson. Thank you.
Plead to be not guilty, Judge.
All right, ask bond.
Yes, Judge, as to bond, Mr. Henson is from Cincinnati. He is the full-time caregiver for his elderly mother. He lives with her. I have good contact information for both him and his mom, Judge. He has 0 failures to appear, no violence on his record. We would be asking for an OR bond. This is a theft from Dollar General where the complaint states that whatever the items were, they were alleged to have been taken to help support a family.
From the state.
Your Honor, the state would be asking for a stay away from all Dollar General stores.
Mr. Henson has 2 felonies, 6 misdemeanors. There are 0 prior failures to appear. It looks like he was on EMD
I was confused about
at the time.
Yes, and then it states that he was interviewed in the Claremont County Jail, and it's my understanding that he was not read Miranda. I think there's some issues.
Yeah, probably. What's the date of this alleged incident?
It is July 2nd.
Yeah, he got out of jail for theft in June. It looks like there might have been a probation because I have Claremont County probation.
Yes, I think he was taken into custody there. And he has told me like he has already like resolved the stuff in Claremont County, Judge, and that he is ready to resolve this. We asked him for an OR.
OR EMD. There is a Warren County order. Jonathan James. These are all. Are you all resolving these today?
Yes, we'd like to.
Yes.
Offer is Okay, we are ready, Judge.
All right, what is the plea to?
Your Honor, it's my understanding the defendant is going to plead to the A charge on the case ending in 2072, the driving under FRA suspension, and the remaining charges will be dismissed for plea.
That's unclassified.
That's correct, Your Honor.
Mr. James, the guilty plea is a complete admission of guilt. This is an unclassified misdemeanor, carries no possibility of jail time. Maximum possible penalty is up to $1,000 in fines and costs, up to 500 hours of community service. You do have the right to a trial. Knowing your right to trial, the maximum possible penalties, do you want to maintain a guilty plea to an unclassified driving under FRA suspension? I'll accept the plea. Counselor, do you waive and stipulate?
Yes, Judge.
Finding of guilty, mitigation.
Yes, Judge, in mitigation, Mr. James has told me that he recently lost his job. He was working at Verizon. He spent a night in jail. He has 2 children, a 12 and 15-year-old who he helps financially support. We would be asking for credit time served, Judge.
From the state.
FRA merged, no, we'll defer on sentence.
Mr. James, did you want to say anything? You have the right to, but you do not have to. 1, credit 1, remit fines and costs. Leach.
Thank you, Judge.
Thank you, sir.
So then, come on, please, get what I'm ready, come on. Right in the middle, your attorney does the right on, and she'll do all the talking for you, right? All right, thank you.
Leo, be not guilty, Judge.
Hold on, which one is this?
Leach. And then Lynch is
I have it, yes.
Leach
State.
and Lynch is next, yeah, I was confused with this one also.
I had a bunch together. Okay, all right. On Mr. Leach, Esteban.
Yes, Judge, he is 47 years old and has no record whatsoever that I'm seeing, along with that 0 failures to appear. He works at Red Box Plus. He drives box trucks for them. He has a CDL license, Judge. He has another place to stay. He can stay with his parents or his brother. I have good contact information for his parents and for brother and for him, Judge. We would be asking for an SOR bond.
From the state.
Your Honor, it looks like the allegations are that the defendant showed up to the protected party's house and was at her rear door when officers arrived and arrested him. There is a protection order in place. I would be asking for a stay away from the prosecuting witness and order for
There's no record, no failures to appear based on the allegation of going to the protected party's home. The bond will be OR plus juris if requested. Lynch.
I'll come talk to you.
Oh, wait, or plus jurist, no. Right with you, man.
He would be not guilty, Judge.
Esteban.
Yes, as to bond, Judge, Mr. Lynch is executing the temporary protection order right now. He has 1 failure to appear, but no violence on his record, Judge. He has a separate place to live apart from the prosecuting witness. I have good contact information for both him and one of his family members. He works at WW Custom Fabrication. He's a welder. He's been doing that for 40 years. He was supposed to have work today at 6 a.m. He is currently missing his shift. He's wearing his work shirt right now, Judge. We would be asking for an SOR bond because he has signed the TPO, no violence on his record. He'll come back to work, Judge.
From the state.
Judge, I would just be asking, it sounds like the TPO is going to be executed, so we'll defer on bond.
There's no history of violence, no allegation of a weapon, 1 prior failure to appear.
He believes it's
And
traffic.
he's executing the TPO. The bond will be supervised or with the TPO. the DV plus juris if requested.
We get off our time. You're good, good.
Manu,
First again.
Manarakiza.
Yeah, this is not guilty.
One count of theft, there's one violent misdemeanor, 4 misdemeanors, 1 failure to appear. Is there anything from the state?
Just asking for a stay away from dollars.
Supervised OR plus stay away.
Thank you,
Did you want to add anything?
There you go.
Dante Moats.
Your Honor, if he could continue until tomorrow, I was not able to keep it.
Supervised, you was left, go out in the hallway.
Continue room A to tomorrow. Mock.
Pardon, she was the. You could consider it dinner. I mean, mock, not moods.
Our plea for Ms. Mock is not guilty.
All right, as to bond.
Your Honor, as it relates to Vaughn, the alleged victim here is an ex-boyfriend of hers. If she is released, she will agree to stay away from him. She is currently in felony drug court, and she reports to me she's doing very well. She's doing their intensive outpatient treatment. She's residing in sober living. I only showed 1 failure to appear, but based on the fact that she is in drug court, she is in sober living, we would ask the court to consider granting her an OR bond.
From the state.
Your Honor, the allegations in this case are that the defendant damaged the vehicle of the prosecuting witness, so I would be asking for a stay away from that prosecuting witness.
There are 14 misdemeanors, 1 prior failure to appear. It'll be the standard bond, which is $1,000 in any way, or alternative ORND. There's 4 pending charges.
Thank you, Judge.
Payne.
There's a juvenile holder.
Left hallway, 10 minutes.
Is this a good M1?
Your Honor, with the child support suspension, so it should be a 4510.
Your Honor, he is going to enter a plea of guilty to that as amended.
Mr. Payne, a guilty plea is a complete admission of guilt. The amended charge makes this an unclassified misdemeanor, carries no possibility of jail time. Maximum possible penalty is up to $1,000 in fines and costs, up to 500 hours of community service. You do have the right to a trial. Knowing your right to trial, the maximum possible penalties, do you want to maintain a guilty plea to an unclassified driving under suspension?
Yes, sir.
All right, Counsel, do you waive and stipulate?
Do, Your Honor.
That includes waiver of service of a new complaint and arraignment,
Yes, Your Honor.
finding of guilty, mitigation.
Here, he spent 2 nights in jail. He does have a holder on him from juvenile court for child support. I would ask for credit for time served.
From the state,
Insurance was mentioned now, we can 1 second.
to credit to remit the fines and costs. Kelly Powell.
Please, not guilty, Your Honor.
All right, what number is this? I have it as a first. Do you have anything different? I just have no.
I have this first as well.
Is there ALS,
There is an ALS in place.
FRA?
FRA marked no. There was a refusal in this case.
Accident?
No accident.
All right, this is a first. Is there anything from the state on this?
No, Your Honor.
Or?
Thank you, Judge.
Ruffin? Are you here on Ruffin, ma'am? All right, you can go right here, come up here to this box. Do you have your, what's your name?
That is the prosecuting witness.
I'm you want to check out eight?
Yes.
Yes, sir. She has an Valley, Ohio ID 4A, Salita Slayton.
Good morning, ma'am. What would you like to say?
I just wanted to say, this was like a whole misunderstanding between us. It wasn't no violence or anything. I don't know where things got confused at with the officers, but I was telling them that I didn't want him to be arrested. And I don't know if I don't know if whatever he said to them, I don't know if that's what got him arrested, but he didn't cause me any physical harm. He didn't do anything to me, and I would like for him to be released. And on top of that, he has to bury his grandmother tomorrow. And he really needs to be there because he's one of the pallbearers. This is just like a big misunderstanding.
Are you concerned for your safety or the safety of any children?
No, ma'am.
All right, is there anything from the state?
I will just note, Your Honor, that the officers put in the complaint that there was visible injuries on them.
Do you want a protection order? Or Sullivan?
That's all I go. Just plug it right here.
Judge, the plea is not guilty on behalf of Mr. Sullivan.
All right, Esteban.
Thank you, Judge. Esteban, Mr. Sullivan is 37 years old. Judge, I do have good contact information for him, including an address locally where he lives with his grandmother. Judge, he absolutely denies the allegations here. Sounds like the two of them were having a dispute over some money. She was driving the car, made a couple of statements about driving the car into traffic or into a wall. Multiple times she would pull over the car, get out, run towards the house, acting like she was asking for help. Judge, he is adamant that he did not put hands on her. I will just submit on that, Judge. We're asking for an OR.
From the state.
Your Honor, I would be asking for a stay away from the prosecuting witness in this case.
And Judge, I don't believe there will be any issue with him staying away.
There's 1 violent felony, 1 felony, 5 misdemeanors, 3 prior failures to appear.
Judge, if I may just acknowledge, I believe the violent felony is from back in 2018. I just think some of those are a little bit older.
Bond, 1,500 anyway, plus juris if requested, plus I'm putting him on pretrial random.
Judge, would you consider an alternate or EMD?
No. Actually, there's no other guideline. I will.
It's the alternate with jurist.
I'm just gonna do OR plus EMD plus jurist requested.
Okay.
With the randoms.
Thank you, Judge.
Wilburn,
Yes.
that's the bond.
Sorry, one more, Judge.
Yeah, please.
Please not guilty on behalf of Mr. Wilburn, Judge, and as to bond, Mr. Wilburn is 27 years old. Judge, I do have good contact information for him as well as his mother and his grandmother. Judge, he is going to execute the temporary protection order. Judge, he is not currently working. He lost his job back in May. Judge, he does deal with depression. He also indicated to me that he would be interested in possibly engaging in some alcohol treatment. I do plan on doing a social work referral to get him connected to some resources. It sounds like when he lost his job, he lost access to counseling and therapy, which I think would be of support to him at this time, Judge. I show 0 failures to appear. He has no record, no history of domestic violence. As mentioned, he has family support. He does not live with his father. He is fine to stay away. Again, he did execute the TPO, Judge. With all of that, asking you to consider an OR.
From the state.
It looks like the prosecuting witness in this case is the defendant's father. The defendant did send threatening text messages to his father stating that he would kill him. He then showed up at his residence saying the same threats to him. So these are, I believe, charged from the same conduct. I would be asking that the TPO be executed, and we will defer on bond on the remaining.
OR plus jurist if requested. There's no record, no failures to appear. Based on the information from today, there will also be a tag unit. No alcohol is a condition of bond. Wolford.
That's how I meet you in 10 minutes. Let's know our plus, Wolford! Sure.
Judge Sophia is not guilty on behalf of Mrs. Crawford.
All right.
Judge Esteban, Ms. Walford is 20 years old. Judge, I do have good contact information for her, including an address where she lives locally with her grandmother. Judge, she works at Nordstrom. She's a sales associate there. She's been there for 3 or 4 months now. Judge, I show 0 failures to appear, an ORS score of 2. She has no domestic violence history, no violent convictions that I see. Judge, from speaking with her, it does sound like she acted in self-defense here. It sounds like the prosecuting witness put their hands on her and that she was defending herself. She is willing to sign the temporary protection order. She's executing that now, Judge. With the TPO, with the lack of history, would ask you to consider OR, Judge.
From the state.
Your Honor, the allegations in this case are that the defendant bit her mother on the arm and leg, causing visible injuries. I would just be asking that the TPO be executed and we will defer on bond.
There's no record, no failures to appear, no weapon. It'll be OR plus the TPO.
Thank you, Judge.
Woods.
So maybe you're saying like 20.
Yeah, this is 21 series.
Judge, we do have a resolution this morning for Ms. Woods.
Which is?
Judge, she is going to be pleading guilty to the case numbers from 2022, case number ending in 3666.
All three counts?
Yes, Judge, and my understanding is the 21 series would be dismissed.
Ms. Woods, a guilty plea is a complete admission of guilt. The Mark Lanes is a minor misdemeanor. Maximum possible penalty is $150 fine plus cost. The two driving under suspension offenses are unclassified misdemeanors. Maximum possible penalty is up to $1,000 in fines and costs, up to 500 hours of community service. You do have the right to a trial. Knowing your right to trial, the maximum possible penalties, do you want to maintain a guilty plea to a Mark Lanes violation and 2 counts of driving under suspension? Counselor, do you waive and stipulate?
Yes, Judge.
Finding of guilty. Mitigation.
Thank you, Judge. In mitigation, Ms. Woods is 35 years old. Judge, she is the mother of 3 children, age 16, 12, and 11. Judge, she does work. She works for Honey Baked Ham. She's been working there since January. She's actually missing work right now. She is also getting a bachelor's degree in healthcare administration from the University of Phoenix. She indicates to me that she's actually on my dean's list right now. Judge, my understanding of the situation is that Ms. Woods, a few years ago when she picked these up, was kind of in a different place in her life. I understand that she recently was released from Warren County. She did some time there. And ever since being released from there, she really has been trying to get her life back on track, Judge. She has an apartment. She has a job. She's getting an education. She's trying to do everything she can to take care of her kids. I'm just asking you to give her credit.
From the state?
Your Honor, there was an accident in this case. It was marked as non-injury. Insurance was marked no. We'll defer.
1, credit 1, remit the fines and costs.
Which means you're out of my care performance test.
Thank you, Judge.
Thank you. Tiana Grimes, she did respond.
Yep, Mr. Grimes, come on in, let's speak.
Good morning, Ms. Grimes. All right, Ms. Grimes posted the standard bond. Is there anything else?
Just asking for a stay away from Tamika Costin.
All right, Ms. Grimes, it'll be the same bond that was already paid, and then you just need to stay away from the prosecuting witness, all right? You'll go to the 117 and then contact an attorney prior to the court date that you set over there, okay? 117, to go out that door. Thank you.
And Judge, on tomorrow's schedule, it says Judge Silverstein. Are you doing bond setting tonight?
It is me. They put in the wrong.
Okay, we just wanted to make sure that we called the right judge.
I am here all week.
Did I call Bonner? She said.
Bond setting?
Do you set Bonner?
Yes, 7.
7, in it. Yeah, thank you. Is everyone waiting on?
Thank you, Judge.
Thank you. Have a good day.
12:30?